Okay, today we are talking about Chapter 3, Essential Elements of a Crime. And this is going to be in conjunction with your Blue Book, Chapter 1 on Introductory Matters. So you're definitely going to want to read this, and it actually may help you understand the lecture a little bit more if you will read your Blue Book, Chapter 1 before you listen to the lecture. So you'll want to look at that. Uh, Especially when we go over principles of liability as far as culpable mental states. So before something has to be a crime, you're going to have a voluntary act. So, and this is straight from the Revised Statutes of Missouri, so RSMO is the abbreviation for that. A person is not guilty of an offense unless his or her liability is based on conduct, which includes a voluntary act. So a voluntary act is something that you intended to do. It's not going to be a voluntary act if it's a result of some type of disease, say epilepsy or something like that, and which was caused a body motion that resulted in you striking another person. There was no voluntariness to that. You didn't control it. People have argued that they've committed crimes while they were sleeping and used that as a defense. Some cases it may have worked because they said, it wasn't a voluntary act. I did that while I was sleepwalking or something that effect. So a person is not guilty of an offense based solely upon an omission to perform an act unless the law defines it. So omission is failure to do something. So when we start talking about a crime, we say by act or omission. Did you do something or did you not do something? So a crime by omission could be something like not paying your taxes. You become criminally liable when you fail to do something that you're supposed to do. And we're going to talk about that more. So conviction of a crime, the elements must be proven beyond a reasonable doubt. Uh, it's not enough to prove that it's probable that an element, the proof must be such that a reasonable person would agree that the elements of the crime are present. There's just no other explanation other than this person did it. Proof beyond a reasonable doubt is not 100%, but there's no other reasonable explanation. Now, that is for a criminal case. For a civil case, we look at preponderance of the evidence, which is actually a lower standard, but that means more likely than not. So, preponderance of the evidence versus proof beyond a reasonable doubt. We make an arrest off what's called reasonable suspicion, and that is lower than proof beyond a reasonable doubt, but it's not enough for conviction. So, reasonable suspicion would be facts and circumstances that would lead a reasonable person to believe a crime's been committed. Beyond a reasonable doubt would leave no other explanation other than this person was guilty of that crime. So true crimes, always going to be two parts to it as far as a true crime, which is the actual guilty act or the actus reus, and then the mens rea as far as the guilty intent, and then scienter, which would be knowledge. So something that would involve a scienter is assault on a law enforcement officer. You would need to know that person was a law enforcement officer for the assault on the law enforcement officer. Otherwise, it would probably just be an assault when we're looking at that. So concurrence, when we look at the true crime, the actus reus and the mens rea need to happen in conjunction with each other. So most crimes require the concurrence of the guilty mind and the guilty act, except for ones that are strict liability crimes. So generally these are regulatory, so start thinking traffic laws, speeding. You don't have to intend to speed to get a speeding ticket. You're going down the road, you're not paying attention, and all of a sudden you get pulled over, you're doing 10, 15 miles an hour over the speed limit, and the officer, asks you, do you know why I stopped you? No, well, you were going this fast. And you can legitimately say, I didn't know. That doesn't preclude you from not getting that ticket, and it's not going to necessarily be a defense. Same thing for liquor violations. You're the clerk at a store, somebody walks in and looks to be a certain age, but they're not, and you sell them alcohol, that can be an issue for you. Food purity, drug offenses, hunting and fishing. A lot of the statutes on hunting and fishing say that you can take a certain, species at a certain time of year, and you can only possess so many of those. So you kind of got to know what those are, and because you didn't know doesn't mean that you won't get in trouble. So let's say you're goose hunting and you shoot the wrong species of goose, and you thought it was the other one. It doesn't really matter. You are still guilty of that issue. So elements, again, the act. So the actus reus, or the forbidden act. The mental element. So what did I, knowingly, purposely, recklessly, criminal negligence? Was there some kind of harm, either to another person or loss of damage, or was the injury to the state? Uh, so the cause element, the harm done, was the natural and probable result of the wrongful act. You go up and you strike somebody. Obviously, you were angry, so the assault would be the forbidden act. Your anger, so you intended to hurt that person, so you have knowingly as far as your mental element. Harm element, the wrong done, so the actual strike. And then the cause element, the harm that was done, the natural probable result of the wrongful act. They caused pain because you struck them when we start looking at that. So model penal code, criminal code drafted by American Law Institute, which was a group of lawyers and judges, law professors, that said this is generally what should be in your criminal statutes for the states. And then the states took that and modeled their statutes off of those. Now, it's not going to be exactly, it depends on the state. Different laws may read very similar but have different names, but generally they're going to start looking at those as, this crime is this in this state. The same elements may be a crime in another state, but it may have just a little bit different name. So again, forbidden act, actus reus, crime is an intentional act or omission. An act has to occur for there to be a crime. So there are different acts for different parties to the crime. So the person who actually did the crime, a person who conspired. So conspiracies, we plan something out, excuse me, and then I didn't necessarily actually go along with the crime, but I helped plan it, or the person who aids. So we talk about this maybe a bank robbery. So we plan a bank robbery, and I tell you that, hey, at this time, this is where the money's at, and this is how you go through here, this is what you do for here. And then two other people that are involved with my conspiracy, they go actually do the robbery. They come back, and then I hide them while the police are looking for them. Or a third party actually hides them. We may have several people guilty of the same crime, but in different parts. So failure to act, again, we've talked about this, small percentage of crimes. So failure to report the death of a child could be one. Failure to report the death of any person, if you are responsible for that based off your state law. Failure to report the location of a human corpse in Missouri, that's abandoning a corpse. Failure by a parent or guardian to provide adequate care for their child. So we would call that neglect in our state, that you are responsible for that person and you failed to live up to those responsibilities, and it was required by law that you do so. Failure to submit to a breathalyzer in some states when lawfully requested to do so. Now, this actually has a civil penalty in a lot of states. So for like our state, if you fail to give a sample of your breath when requested in relation to driving while intoxicated, it might not going to necessarily be another criminal charge, but you are going to lose your driver's license for a year for failing to do so. Where if you blew over a certain level, as long as it was your first DWI, you would probably receive around a 30-day suspension. The driver's license is part of that civil, and you would lose it for not following what the rules are. Implied consent is what it's called in Missouri, and that's where we work on trying to make people responsible for when they drink and drive. A homicide by omission, you didn't do anything when you know somebody was going to be killed. Failure to act if the person is in contractual agreement and a person is harmed. So I was responsible for a person, let's say I was taking care of somebody with disabilities and I had gone through all the legal actions to take care of them, and then I failed to do so and they were injured as a result. Culpable mental states, this is directly from our state law. So again, RSMO stands for Revised Statutes of Missouri. And there's 4 culpable mental states that we're going to look at. The first one is purposely, and I've taken out some of this. You can go to the statute 562.016 and look the rest of it up, but briefly, it's their conscious object to engage in that conduct or cause that result. So purposely is the highest one as far as proving that, I did this act on purpose. The next one we look at is knowingly. And a person acts knowingly, that they're aware that their conduct is practically certain to cause that result. I know that if I'm mad and I go up and hit you, it's practically certain that it's probably going to cause some type of, at the very least, pain. And so it was practically certain to cause that result. Recklessly, a gross deviation from the standard of care which a reasonable person would exercise. So I disregard that risk. And so instead of driving the speed limit on the correct side of the road, I drive in the middle of the road at a high rate of speed. So I'm failing to maintain lanes and I'm exceeding the posted speed limit. I'm being reckless. And I know it's wrong, but I'm doing it anyways. So that's that reckless or careless and imprudent driving. Negligence, criminally negligent when they fail to be aware of substantial and unjustifiable risk. There's certain things that we expect of adults that they anticipate that there could be an issue with this. So, and if a person doesn't do that, that's where we look at it as another, a criminal act. So criminal negligence is the lowest, and so when we look at a criminal negligence charge, this may be something as simple as like second-degree trespass, where you should have known you shouldn't have been on somebody else's property, but you walked on there. A lot of criminal negligences are going to be misdemeanors, even down to infractions. So exceptions to mens rea, Supreme Court has never created a doctrine that requires proof of mens rea in all crimes. So, and the states are generally free to create a law that doesn't require it. Again, when we start talking about lack of mens rea, we're looking at strict liability crimes in that there's nothing required that says we have to have a culpable mental state. So examples would be felony murder doctrine in that, I'm with somebody and they commit a felony. So they walk into a liquor store and they shoot somebody. I have no knowledge whatsoever of what they were going to do and weren't even with them when they did it, but I was involved with the actual crime. So I'm guilty under that felony murder doctrine of the death of that person. So strict liability crimes like we talked about before as far as traffic, liquor violations, and then possession alone as far as a crime. So this could be start thinking about illegal drugs, illegal weapons, or certain people can't possess certain weapons. So when we start again looking at our culpable mental states, think of it as a slope, and negligence is on the lowest end, and then that purposely is on the highest end. Most of the time when you are looking at your statutes, a lot of them are going to fall in this range right here, that knowingly. So accident, a pure accident is generally not a crime unless it's specifically mentioned. So, and our statutes, as far as Missouri goes, says accidents are an excuse for offense. Conduct would otherwise constitute an offense under, the chapter is excusable and not criminal when it's a result of an accident in any lawful act by lawful means without knowingly causing or attempting to cause physical injury. So if you're not trying to cause an injury, but one happens, so you're wrestling and somebody is hurt. Let's say we get a broken wrist or something like that. Normally that would be a crime, but because it was an accident, there's no criminal activity. It's up to the person that is charged to say, hey, this was an accident. Ignorance, the old maxim, in ignorance of the law is no excuse, is applicable in a lot of crimes in that laws are published. So when we start looking at laws, it is available to everybody, though sometimes it can be kind of difficult to find. Now in the age of the internet, it's quite a bit easier. If you want to look up a law, for lack of a better word, we could Google it and try to find the state laws and probably be fairly successful at it. So a person's not relieved of criminal liability because they believe their conduct was not an offense. There's a few things that we can work around that. If I act in reasonable reliance upon an official statement of law, afterward determined to be invalid, so a state statute, an opinion or order of a court, an official interpretation. So there I'm looking at, I can make a mistake, but I fell back on something that would be reasonable. So type of mens rea, so type is, when we start talking about intent, specific intent, party intended for the desired result to occur. First degree murder, I planned it out. My conscious object and desire was to end the life of this other person illegally. Versus a general intent, I didn't necessarily, intend for it to happen, but it did. I was mad at a person and I got in a physical altercation and they were hurt worse than what I intended. So if degree of mental guilt is made an element of the crime by the law, the prosecutor's got to prove it as far as that goes, as far as specific or general. So proving a mental element, how we're going to prove it, we can show the acts of the defendant and the circumstances that surrounded the crime. We can present evidence in court, such as statements, which would be testimonial evidence, physical evidence, documentary evidence, showing that this person intended to do this crime. So one can reasonably infer that a person ordinarily intends the natural and probable consequences of his or her actions. So when somebody does something, we look at it as, that's what they intended to do. So it wasn't a mistake. We didn't get something wrong. It was our natural intention. Now, do mistakes happen? Yes, but it's generally going to be up to that person to prove it was a mistake. So innocent acts that could be criminal, one of the ones that come to mind for me is possession of precursor chemicals in relation to drugs. Back in the late 90s, early 2000s, Missouri had a big issue with manufacture of methamphetamine. Well, there's a lot of chemicals that are used in manufacture of methamphetamine that would be common to households. Iodine, if you were raised on a farm or dairy farm specifically, you use iodine as far as cleansing, antibiotics, different things like that. Other chemicals would be like Coleman fuels, like the camping fuels that they use for stoves. It's legal to possess that, but if you were using that as part to manufacture methamphetamine, it would be illegal to possess it. So sometimes things that are normally legal to possess can't be possessed for the wrong reason. Burglary tools. I'm walking down the street. I've got a hammer and a screwdriver with me. It is totally legal to possess a hammer and a screwdriver. But if I'm walking down the street looking for somewhere to break in and I'm going to use those tools to make entry into that location, then it becomes a crime to possess the hammer and the screwdriver. So when we find somebody like that, we have to show that intent on the part of them. When we're interviewing them, we point blank ask them, were you going to use the screwdriver to jimmy the door? Or were you going to use the hammer to break a window? So what were you using that item for? Even teaching something as simple as, how to make a firearm. It's not illegal. You can go on the internet, different classes that you can take and learn how to manufacture different devices. But if we are teaching that to a person knowing or believing that they're going to use that to cause injury or death, then it becomes a crime. So scienter basically means knowledge, like we talked about a while ago. The person that assaults a police officer, they need to know that they're a police officer. Another one to look at is receiving stolen property, which falls under our stealing statutes. So a person has to believe that that property is stolen before we can charge them with receiving stolen property. Now, believing versus knowing is a lot lower standard, so it's a little bit easier to prove. But generally, again, the person just has to have knowledge that about the other aspects of that crime. So many criminal codes, an element that accused has knowledge of the crime. If a statute requires knowledge about the existence of the fact, that knowledge must be proved by the prosecution. Again, that's where the investigator comes in as far as the correct questioning and finding that information. Examples of crimes, like we talked about, assault on a police officer, refusing to aid a law enforcement officer, receiving stolen property, harboring or aiding a felon. I need to know that person's a felon. If I'm letting, a friend spend a couple days with me and somebody knocks on my door and says, hey, is so-and-so here? And I say yes, and didn't realize that they were running from law enforcement, I am not guilty of aiding or harboring that person. At the same time, if I did know and the law enforcement officer came up and said so-and-so here and I denied that they were there, saying nope, haven't seen them, I could be complicit as far as aiding or harboring or whatever the statute says for your particular area. So willful blindness cases that raise a lack of knowledge as a defense where they ignored it. So instead of finding something out, which wouldn't have been that hard to find out, I just decided that I wasn't going to do anything about it and just bury my head in the sand. The judge can give instructions. that says, hey, this person had ample opportunity to learn the facts of this and they chose not to, and then the jury can take that into consideration. Motive versus intent. So intent, the mental purpose, like we talked about a while ago, the couple mental states versus the motive. So think of motive as emotions. So why was I doing this? Jealousy, anger, greed. What was my motive as far as doing that? So in criminal law, motive refers to the reason that the defendant committed the crime. The mental purpose or design to commit this specific act is called the intent. So as far as mistakes go, certain laws were made to protect children, but at the same time, mistakes can be made. Now, the higher the offense, usually we're going to forgo that, and we're not going to let somebody say that they made a mistake. A lot of times that age revolves around that 14-year-old, 12-year-old, under those ages. We definitely take those mistakes away when we start reading state statutes, and those change. So what is, not necessarily a crime today may be a crime when the legislature rewrites that statute. This is mistake to age consent, not a defense win. The criminality of conduct depends upon a child being less than 14 years of age. It's no defense that the defendant believed the child to be older. So what this statute is saying, that even though this person said that I believe this person to be, the age of adulthood, reality they were 13 years old. We don't care what they look like. We don't care what they said. We're still going to hold the adult responsible for their conduct. So cause and fact versus proximate cause. So the result would have happened but for the prohibited conduct versus proximate, sometimes called legal cause, which is ordinary and probable consequences. For crimes in which harm has occurred, the state must prove the defendant's act was ordinary and proximate cause of that harm. So requirement of the Freedom Act caused the resulting harm. Did I do something that caused the harm? Problems that we would run into, let's say that somebody shot someone and a substantial time occurred. Maybe it broke the spine, so they were paralyzed. The person gets pneumonia, which is a result of paralysis, and they die, 2 or 3 years later. We could still show that the cause was actually related to the shooting. They wouldn't have been paralyzed. They wouldn't have got this type of pneumonia, but for the person having shot them. So examples, A slashes B's tires, stranding B on the highway. While B is waiting for help, C comes along and kills B. So B is now dead. A's act of slashing B's tires is the cause and fact of B's death, because but for the act, B would not have been stranded on the road. So 2, A stabs V, inflicting a non-mortal wound that by itself would not cause V's death. So we have an assault. But acting independently, B shoots V in the leg, causing a similar non-similar wound. So we have another assault. The 2 wounds together, though, actually cause V's death. So 3, A stabs V, causing a mortal wound that will cause V's death. Before V dies, B independently shoots V in the head, which also inflicts a mortal wound, from which V will die whether or not A has stabbed him. So in theory, neither A nor B caused the person's death, but at the same time, we're actually probably going to charge them both under different statutes. So A stabs V, inflicting a mortal wound that will cause V's death in 30 minutes. Before that time ends, B shoots V in the leg, inflicting a non-mortal wound. The increased bleeding from B's wound causes V to die 20 minutes faster. While A's mortal wound is the but-for cause of V's death, in theory, B's actions are not. Again, both are probably going to be charged as in that death of that person. Year and a day rule, this was based a lot off of the old type of medical care that wasn't great. And what the law generally said is that you couldn't be charged with murder if the person died over a year and a day from the injury. So from when that injury occurred, if that person lived over a year, you weren't necessarily guilty of that. Now, because medical care has got so much better, it's not uncommon for a person to live longer than that, be it through life support or other means. And so most states have said, no, we're going to do away with this, or we're going to change that law. Possession. When we start looking at possession, the mental element requiring possession offenses during that intent or knowledge. I have to know that I've got it. So illegal drugs and certain weapons definitely going to be that. But at the same time, let's say somebody hides drugs in somebody else's car, or they're the passenger in a car and they're carrying illegal contraband and they get pulled over and the passenger leaves that contraband there. If the driver can, legitimately say, I didn't know that was there, then they're not going to be necessarily guilty of that possession. Offensive carrying an unauthorized concealed weapon requires a showing of actual possession. Then weapons offenses are different by jurisdiction. As far as Missouri law goes, carrying a concealed weapon may not necessarily be an offense, but you cross state lines and the next state it may be. So possession alone is a crime. All states make possession of certain objects a criminal offense. So uh, basically we look at ownership as possession. Having actual constructive possession of an object with its knowledge or presence. So we're going to talk about actual versus constructive possession. So a person has actual possession of that subject, has the object on his or her person or within easy reach. So if I can touch it within reason, then it's actual possession versus constructive possession. So person has the power and the intention at given time to exercise dominion or control. So let's say I'm a drug dealer and I've got a safe house and I keep all of my drugs locked up at this house. Even though I'm not in that house, I still have constructive possession. One of the easiest ways to show that is, do I have the keys on my person? So if I've got the keys to the house, then definitely I have constructive possession. So possession may also be sole or joint. So if one person alone has possession of an object, possession is sole. If two or more persons share possession of an object, then it's joint. So presumptions and inferences. Presumption, facts presumed to be in existence because of proof of other facts. You'll hear the word predicate facts. Presumption of innocence until proven guilty is probably the best example of there, versus an inference is permissible conclusions that can be drawn from proof of certain facts. A common inference used in criminal trials is that a person intended the natural and probable consequences of their deliberate acts. I did it, so I meant to do it. Presumption of innocence, designed to place the burden of proof in criminal cases on the prosecution. And again, they must prove it beyond a reasonable doubt in that criminal case. Presumptions overcome elements of crime only by proof beyond a reasonable doubt. So when the person, even though they're on trial, until they are found guilty or plead guilty, they are presumed to be innocent. So elements that may be essential in the proof of a crime, the actual forbidden act is probably going to be the main part of it. What did they do? We may need a mental state. In fact, most crimes are probably going to have some type of culpable mental state, and we will take motive into consideration when we start looking at the mental state. Do we have to have knowledge? So do we have to have knowledge that the property was stolen? Do we have to have knowledge that the person was a police officer? What is there? And then the actual possession, so either constructive or actual, and then whatever the state statute says the law is. And then, did we prove the harm, prove the age of the victim, other essential elements that may be required by that statute. In most cases, when we start reading statutes, they're not extremely complicated. We just have to read them very closely. So again, legal presumptions. All adults are sane, normal, and competent is a legal presumption when we start looking at somebody. We think that all adults are responsible for their actions. And defendants in criminal cases are presumed to be competent to stand trial unless somebody can prove otherwise. All right, so that is the end as far as this lecture goes. Remember, you can review this as many times as you want and then go ahead and take the exam that goes with us. Reminder that the exam also does include test questions from Chapter 1 of the Blue Book in addition to your vocabulary. So before you take this or attempt it, you need to make sure that you've went through the material as far as this lesson goes.